वेलकम एवरीबॉडी, अभिवादन आप सबका। और आज का ये सेशन जो है ये बेसिकली रखा गया है इसलिए क्योंकि a lot of people want to be entrepreneurs now. They would like to start their own ventures and they are looking for guidance in a number of areas, especially the legal, because most of the technical people are oblivious or they are ignorant of the legal issues and the rules and regulations. So it was with that in mind that the Textile Association Delhi decided to have this webinar so that an interaction between participants and two learned people from the industry who are also fully engrossed in the legal profession, they can be guided by them. First, I would like to welcome Mr. Vijay Sharma. He is a pass out from TIT from 1978, my batchmate. We started our career together in GRG. ये बेसिकली प्रोसेसर हैं और शॉप फ्लोर पे इन्होंने काम किया। फिर उसके बाद में he started his own venture. So he has a background of service in the industry. He also has a background of entrepreneurship himself because he was an entrepreneur for a certain period of time. And when things became difficult because of the legalization of the process houses, he decided to close that, recover his money, and in the meantime, he studied law. So he is now a qualified, full-fledged lawyer. He has a chamber in the Delhi High Court, and he has been pleading and winning. I would like to stress on that, pleading and winning most of the cases that he has taken up so far. Please correct me if I'm wrong. So welcome, Mr. Vijay Sharma.
Thank you.
And the other gentleman is Dr. R.S. Antal, TIT 1981. And he has had a long career. He has been, I will not go into complete details क्योंकि उसमें फिर पूरा टाइम निकल जाएगा। इतनी लंबी चौड़ी list of achievements है अंटल साहब की। But he has been on the shop floor. He has worked with the skilling councils. He has worked with the academia. And last, he retired as joint director of the skilling university. And now he has taken his license as a lawyer. And he's also now a full-fledged lawyer. So with that, I hand over the mic to Dr. R.S. Antal, who will take us forward. Welcome, everybody. And I would request all of you to try and extract the maximum information and the maximum knowledge from these two gentlemen. Together, they have more than 80 years of experience. So please capitalize on that. Thank you. Dr. R.S. Antal, please.
Thank you, Mr. Raji. Good morning to you all. In fact, it's a pleasure to be a part of this today's program, particularly in association with the Mr. Vijay Sharma, who is not only from our own institute, he is a technical, and then he has already started his own venture. And people say that the failure teaches most. And he has been able to wind up that project and thereafter taken up the responsibility of the lawyer. I think he has not only the experience, knowledge of law, but he has personally experienced. People usually say there one person who is burning in the fire and another person who is extinguishing the fire. So the pain is different. So therefore, I think Mr. Sharma is going to speak from heart. Today's context, as Mr. Mishra has already pointed out, India has over 65%, 62% population, which is in the working domain. This is as per the Grant Thornton reports. This is 54% of the population is below the level of 25 years. And after 20 years, the scenario is going to be like that. that the working population requirement of the industry is going to down by 4%, whereas the requirement of the manpower, but availability of manpower will be increased by 34%. Meaning thereby the unemployment is going to be a very serious issue after 20 years. The only solution to this, one of the scenario which is likely to be developed, is that the more and more the startups are coming up, because they not only give an opportunity to self-employment, but they will give the opportunity others to employ in their venture. Another scenario in India which is going on is about 27%, only 27% of the male person goes for higher education. Only 26%, around, say less than 26% of women goes for higher education. Meaning thereby about 75% of the top population which is not going for higher education at all. They are dropping before the 12th. 25% drop at the level of 10th, and thereafter 24%, remaining 25%. This makes 75% dropout. And then scaling, because the government jobs are very limited. These days also, today itself there is a scenario. Some 4 years employment is being generated. There are resentment from the youth. The future is going to, because the government employment is limited. Our education system was attracting the people for government employment. That has changed now. New national education policy has come up. Now emphasis on the skill. But here the problem is our youth is not aspiring to go for these kind of skills. So we have to make that aspiring also. We have to make them some kind of skills. There are various schemes of the government which are promoting these entrepreneurship and startup. So in this context, I think the stakeholders of the startup are the government. Government not only administer the starting of startup, but they provide many schemes and facilities and etc. We have already, there are so many competitions. You wanted to start up something, there are going to some competitions. Employees also, to manage, to hire an employee and to manage an employee, to keep him motivating is also a problem. Consumer act is already there, because the customer is also not so simple. We earlier used to say the customer is God. We say these days the customer is king, because the king attitude is totally different. If he suffer, he is lost, make any loss, then he will file suit against you. Vendors also, most of the things is one of the partners. Society, setting up ventures, we have to take care of the interest of the society also. There are various partners, there are various types of formation of the startup. There can be a sole partner or partners also, tiny or big also. And then you can start the startup without the support of the financial or the banks institution. With these stakeholders, I think there is likelihood that there can be conflict between the business to business, there can be conflict between to customers, there can be conflict between customer and business, and there can be many times the conflict with the administration also, and then public. To avoid that, the government of India has framed various laws, and our learning fellow members, I think we have to take care of the remedy through the laws. And you are not aware about the law is not the excuse. You have to understand. Most of the people, those who are coming to the startup, they lack in these kind of skills, because they know they have business idea. The business mindset is being created by the institutions, but they lack in how to execute. Or then sometimes they forget it. I have come across various organizations. One of the institutions, they did it, but they forget to send a letter, a small piece of letter. If it is sent in time, it can sometimes saves crores of the organization's money. These are very important, that if you are aware what kind of legal or compliances is to be made, then we can save a lot of money. Here in the, if you talk about, when I was discussing in the morning with Sharmaji, I found that there are various fields. Even people used to say that there are 30 laws which are applicable to very small organizations. and some people say it has the numbers has gone it. So some of the areas which I can remember when I was talking to him is about the first is the registration. Registration is also the types of registrations, types of size of the organizations also affect the where to register, how to register, whether it is registered in the Company Act or it is registered with the Society Act or it is registered with Trust Act. There are various forms of registration. Even DIC also registered the organizations. Where there are patent and the private
Mr. Antil,
organizations.
Mr. Antil, sorry for interrupting you for a moment. We have the national president with us.
Voice नहीं आ रही है आपकी.
Welcome, sir. Welcome. I think.
Hello.
Am I audible?
Please welcome the national president, Mr. R.K. Vij.
This सबको आवाज नहीं आ रही. Sir, आवाज आ रही है?
Welcome, R.K. साहब. Welcome जी.
Vij साहब, welcome.
आवाज नहीं जा रही उनको पास.
अंटिल साहब आपकी आवाज नहीं आ रही है हमें.
सर आपको किसी की भी आवाज नहीं आ रही है. हाँ तो ये I think others are listening. There's some problem at your end.
मैं देख लेता हूँ.
हाँ सर बाकियों को तो आ रही है. आप अपने एंड पे एक बार चेक कीजिए.
उस स्पीकर को थोड़ा देखिए उसमें म्यूट तो नहीं कर रखा था. Sometimes you mute.
नहीं सर
आ गई आपकी आ गई. Good morning everybody sir.
गुड मॉर्निंग विज सर.
विज साहब के पास नहीं जा रही ना आवाज. विज साहब की आ रही है.
आ गई
सबके पास किसी के भी
आपकी भी आ गई.
चलिए सर ठीक है सर. थैंक यू वेरी मच. In fact, Mr. Ji wanted to say a few words. Mr. Ji, now you can repeat.
I just wanted to welcome the national president, Mr. R.K. Vij. Thank you for being here. And हम लोगों ने शुरुआत कर दी है आपके बिना क्योंकि काफी लोग इकट्ठा हो गए थे और टॉपिक आपको पता ही है. बाकी अंटिल साहब ने अभी शुरुआत करी है, वो अपडेट कर रहे हैं. थैंक यू फॉर जॉइनिंग सर. थैंक यू सो मच. दो लाइन आप बोल दें पहले, फिर उसके बाद हम लोग शुरुआत कर देते हैं बाकी.
So I, on the behalf of Textile Association of Central TAI, I congratulate Delhi TAI unit that they have taken a very strong and good subject today, because we all are talking something and others, but we are very, very poor in the knowledge of law and other things. We always believe we go at the 11th hour to the lawyers and other things. So I'm thankful to the Delhi TAI team and the speaker of this, Mr. Vijay Sharma and others, so who have taken this step to guide the Textile Association of India members, because now it is very much required, because this now digitalization world has started. One thing, whether it is a right or wrong, it just like within a second it moves to all over the world. If even you have not done anything crime and other things, but still they can change your voice, they can change your topic, they can change your style, and then it can be spread all over the world. So this subject is very well be covered today, I think so. I will be very happy to listen all these points. If any point will be there, I will also raise. Thank you, Mishra ji. Thank you, everybody.
Thank you, sir. Thank you for your kind words. And I'll now ask Dr. Antil to continue, please. Dr. Antil, please.
Thank you, sir. Thank you, Vij sir, for your encouraging words and giving encouragement to the TAI Delhi from time to time. I was just finished my introduction that the importance of entrepreneurship or startup.
नमस्कार.
Then the involvement of labor laws, various laws, various stakeholders. I was just discussing that the
हाँ
registration, type of
आपका काम
registration,
pending है अभी। चलो देखते हैं कुछ तो होगा।
land related issues, hire purchase, if you want to even the organization these days are starting with the virtuals. Marketing, advertisement or consumer act is already there. I was just telling that the consumer is no more the silent consumer. These days they have the right, they have been provided teeth through the Consumer Act. Licensing and permits, these are also very tedious jobs. They also not only required one-time permission, but thereafter the compliances need to be done. Taxes, GST, other compliance, just like deduction of TDS, compliance of the GST, intellectual property right, because the business idea is very important. You have to save that so that it's not copied by the others. That you can whatever energy and money you have spent on it, that the copyright you can maintain you can return back. Privacy and data concern, these are also in fact the there's a clause in the agreement that you will not disclose the concern. Tortious liabilities, then when there are dispute between the two parties, the contracts, etc. Apart from there are labor codes also, IR, safety, environment, these are issues. And that's it, what I want to say is, just like a group went for a tourism, उन्होंने जो है किश्ती को किराए पे लिया और जो नाविक था उससे they are starting asking various kind of skills. क्या तुम्हें, do you know how to read and write? Do you know what are the area of this? So various questions were being asked. तो sailor जो है वो एक ही चीज कहता सर मुझे नहीं आता. And then the people, those who are around, those who are going, जो अपने tourism business पे थे, they used to call him कि भाई अब तुम्हारी 25% जिंदगी तो इसमें खराब होगी, तुम्हें लिखना पढ़ना नहीं आता, तुम्हें खाना पकाना नहीं आता तो 25% और खराब होगी. तो फाइनली उस नाव के अंदर नीचे से होल हो गया और पानी अंदर आना शुरू हो गया. नाविक ने भी एक क्वेश्चन पूछा. He started asking one simple question. सर आप लोगों को स्विम करना आता है कि नहीं आता? तो सभी ने कहा नहीं आता है. तो उन्होंने कहा बस कोई बात नहीं सर, मेरी तो जो कुछ परसेंटेज लाइफ खराब हुई, तुम्हारी पूरी लाइफ चली जाएगी. ये आइडियाज, बिजनेस माइंडसेट, बिजनेस आइडियाज, बिजनेस माइंड, ये सब बेकार हो जाएगा अगर आप लॉज के बारे में नहीं जानते हैं, उनको कंप्लायंस ठीक से नहीं करते हैं, तो वो सब खराब हो सकता है. इन चीजों के लिए आई थिंक फॉर दिस पर्पस मुझे बड़ी खुशी है. मैंने जैसा कि अपने इंट्रोडक्शन में शुरू में बताया था, मिस्टर विजय शर्मा जी जिनको न केवल एक्सपीरियंस है अपने स्टार्टअप को सेटअप करने का, और बहुत सारे लोगों का जो उनकी दिक्कतें आई हैं, कॉन्ट्रैक्ट एक्ट में आई हैं, चाहे आर्बिट्रेशन में आई हैं, चाहे उनको रजिस्ट्रेशन में आई है, उनको हेल्प करने में, न केवल गाइड करने में, बल्कि उनकी प्रॉब्लम को रेमेडीज जो है, जुडिशियल रेमेडीज दिलवाने में भी उन्होंने काफी मदद की है. एक लंबा 1991 से प्रैक्टिस कर रहे हैं और वेरियस कोर्ट्स में वो जाते रहे हैं. तो देयरफॉर आई थिंक द लॉज की जो करंट सिचुएशंस है, जो एक बार पढ़ते हैं, कीप ऑन चेंजिंग आल्सो एज पर द सर्कमस्टेंसेस रिक्वायरमेंट. तो विजय साहब जो हैं आज के जो इस व्याख्यान को थोड़ा सा आगे लेके चलेंगे. एंड देन आई रिक्वेस्ट ऑल ऑफ यू टू, जो आपके मन में कोई क्वेश्चन है तो चैट बॉक्स में डाल दें, ताकि उनका आज या बाद में शर्मा जी जब भी कभी he got the opportunity, he can send you the messages. With these words, I hand over for take up the platform to Mr. Vijay Sharma ji to take the today's discussion forward. Sharma ji, please. शर्मा जी आप. शर्मा जी आप अनम्यूट करें.
मिस्टर विजय शर्मा अनम्यूट करिए अपने आप को.
Hello, am I audible now?
Yeah, you're audible. Yes.
Yes.
Okay, there was
Welcome,
some
sir.
interruption automatically and I went muted.
Welcome, sir.
Should I start?
Please start.
Okay. So today we are talking about startups and their difficulties in setting up their entrepreneur and what are the legal issues involved. That is the primary concern where I shall be taking it forward. So first of all, I would like all of us to know and understand what understanding we have with the word startup. What is all about a startup? A startup is a business or initiative started by an entrepreneur with a goal of finding, developing, and validating his scalable business. So there are primarily two categories. Either we are going as a trader, we are agent of some company, and we want to establish our own entrepreneur as trader. We'll taking goods from him and selling. Again, it goes into two categories. We are selling within countries or overseas. Number two is manufacturing unit. We are starting up a manufacturing unit. So I start with manufacturing unit. So what we are required primarily to start a manufacturing unit is infrastructure. We want land. Land, we can seek allotment of some land from government, first of all, in industrial areas or special economic zones, as in Noida, or we can buy our own land, private land, from any private person. Then we have to make a contract. And for that land and infrastructure, if we are taking it from a private person, and even if we are taking it from government, there has to be some kind of document that has to be executed between the two. And that document and the terms and conditions laid therein would carry weight too much because they regulate the future of the land that we have taken. Now, when we take the land and we venture into starting our own manufacturing unit, then local laws play the primary role. Because we all know from state to state, the local laws are different. In UP, the local laws are different. In Delhi, they are entirely different. So in every state, because it is the prerogative of the state government to formulate and frame their own laws, municipal laws. Pardon? Pardon?
Ms. Khushbu Bharti, please mute yourself. Thank you.
So now I was talking about local laws. So there, what we are required to take permits and licenses. I'll talk about it first. Because before we start our venture, we must pre-apply and we must obtain the required permits and licenses. Otherwise, there will be notices after notices from the government agencies and local bodies, and we'll waste more time in paying fines and all that, and then making compliance of the rules and regulations and local laws. So what we are required to do is, first of all, permission from fire department. We have to take an NOC. For that, we have to install fire extinguishers as per standards given by the local authorities, and we have to seek fire NOC and certificate from the state government offices in the form of safety laws. Okay. Now, after fire NOCs, we have to take, suppose we are putting a dyeing industry, textile industry, printing house, then we have to install water purification plant also. where we are required to maintain the ppm, parts per million of water, which is the effluent from that industry. That should not be toxic. Number 3, we have to take permission from State Pollution Control Board. State Control Pollution Board as well as from Central Pollution Control Board. Both are necessary. Primarily, it is a State Pollution Control Board that will have a check on the industry. So there 3 laws come into play. Air pollution, that is the first and foremost, wherein noise pollution is also must. So number 2, water pollution. Water pollution, as I have indicated, water purification plant and all that, toxic effluents we cannot allow to emerge out from the factory. And air pollution we cannot allow. And again, this noise means noise pollution, which is a part of air pollution. Our machinery should not vibrate to that extent, which is not permissible, beyond permissible limits. So for that purpose, we want NOC from State Pollution Control Board. Then we have to go for GST registration. That is, everybody knows that is the compulsory, mandatory. Now come the labor laws of state government. Labor laws, if we are employing 10 or more than 10 persons in our unit, then we have to go for ESI registration, employment state insurance. If there is salary more than 20,000 per person of an employee, then we have to go for EPF registration. Provident fund we shall have to deduct. And as we all know, 12% is the provident fund that has to be contributed. This is applicable to every establishment which employs 20 or more persons. EPF Act. Here it is not 10. Every such employer shall be required to be registered under EPF on the government website, Employee Provident Fund Organization, EPFO. So the contribution payable by the employer is 12% of what? Of basic wages, DA, and relatable allowances, if any. If you go for voluntary PF deduction, that is not inclusive. Then you have to take care of Industrial Disputes Act. When we talk of labor laws, Industrial Disputes Act and its provisions have to be observed. Factories Act again is an act which regulates the functioning of your factories. Now, the most important part comes when you employ persons or you make any contact with any party. So here the contract law plays the vital role. Now, what is contract? Perhaps we have to first understand what is the difference between agreement and contract. Because this is our common understanding, agreement and contract, they are one and the same thing. No, it is not. What is agreement? Agreement is between A and B, which is not enforceable in law. For example, A and B make an agreement between them. Okay, if A begets a male child and B begets a female child, both will be married. It is not enforceable in law. So it is an agreement. It is not contract. Now I tell what is the contract, because it is very important to know what is the contract. A contract is an agreement. Agreement is initial part. A contract is an agreement between two or more parties. It can be between two, between more. That creates a mutual obligation which is enforceable in law. The definition of a contract suggests that it takes an agreement to a new level with specific rules and boundaries that are legally binding. Signing a contract means you need to adhere to its terms, otherwise there will be legal repercussions. What is the difference between contract versus agreement? In a nutshell, the main difference between a contract and an agreement is that a contract is legally binding while an agreement is not. A contract includes specific terms and regulations which can be enforced by law, while the only requirement for an agreement is that all parties understand their rights and responsibilities. That's all. There is no enforceability in agreement. Now, what are the elements of a contract? Who can make a contract? For an agreement to turn into a contract, it has to include the following things. Number one, offer and acceptance. One offers, the other accepts that offer. This is the first component of a contract. Number two, there has to be mutual consent. It is not that I say so, I offer this and you have to agree to it. No, there has to be mutual consent. Each party enters the contract of their own free will. They agree to the same terms and have equal knowledge and understanding of the contract's terms. Number three, there has to be consideration where it is not there in the agreement. Consideration. Consideration what? Consideration is something of value exchanged by the parties involved, such as money, such as knowledge, such as resources. Both sides must provide consideration. If only one party provides something, this is considered a gift. This is not consideration. And then it is not a contract. Now, both the parties should be competent to contract. What is the meaning of competence with respect to contract in law? Each party should not only understand the contract terms and conditions, they have to be competent to sign it. Who can sign? You have to be major. A minor cannot enter into a contract. So you have to be competent to sign it. In other words, minors, mentally incapable people, or people with under the influence of alcohol or drugs cannot sign a contract. If a party is incompetent, this is a valid reason to terminate the contract. That contract is no longer enforceable if a party is incompetent and does not meet all these parameters, which are essential ingredients for a contract to become enforceable in law. What is the legal purpose of contract? There has to be some, if there is contract, if we talk of contract, then there has to be some legal purpose also behind it. Otherwise, why should one think of it? Hypothetically, you can draw up a contract about anything you want. However, a court won't enforce the contract if its subject matter is not legal. For example, A enters into a contract with B. A says, I'll send your child to USA and get him employed there. You pay me 10 lakhs. It is not a legal contract because this cannot be enforced in law. Unenforceable and illegal. So the terms of contract have to be legal and legally enforceable. Otherwise, you cannot knock at the doors of a court of law in India. In other words, a contract should not contradict a country's laws and public policy of India. What is public policy? What is our understanding about public policy of India? Every statute, every enactment which is made by legislature is primarily based on the public policy of India and public interest, where some public interest is there. So if there is contravention of any provision of law made by parliament, and it is so in our contract, the contract is void, null and void ab initio, because it is in contravention with the public policy of India. and that becomes unenforceable from the very beginning, since inception. When is contract necessary? A contract is necessary when you enter into an arrangement with another party and want to protect your rights. If you are making a contract, you have to protect your rights first. That is your primary concern. So you have, when you enter into a contract, you have to protect your own rights. That makes the contract necessary for you. Of course, it's up to you whether you use a contract or agreement, but in some situations, a contract is must for protecting both sides in the deal. Some examples are giving loans or taking on debt. Then there has to be contract. Selling or buying real estate. There has to be a contract. Leasing or renting a property. There has to be a contract. Otherwise, the interest of landlord is never protected. Tenant will not vacate it unless you have made a contract. Agreement examples, when two parties make an agreement, they don't usually aim at making it legally binding. Technically speaking, any arrangement that includes two or more parties and a common intent is an agreement. An example of an agreement between the parties is when one person offers to share the cost of rent, a second person accepts it. Suppose there are two friends. They take a flat on rent and they enter into an oral understanding between them that we shall share rent of the flat. There is agreement. This is not enforceable in law. Now, contract examples, which are important for industries. Many legal documents called agreements are actually contracts. Number one, non-disclosure agreement. That is essential for every industry, for every entrepreneur. It is also called confidentiality agreement between two parties or more parties. This agreement prevents sharing specific information with third parties. NDAs, non-disclosure agreement, NDA. NDAs are commonly signed between employees and employers first, or business and potential joint ventures. With an NDA, you mitigate the risk of sensitive information leakage, and then you are able to protect your business. Now, when you employ the persons in your unit or industry or establishment, you have to make contacts with them also. What is the requirement of that contract? You have to put all details and all specifics into that contract so that that employee doesn't drag you in courts of law, labor courts, etc. So you have to be very wise while drafting your contract so that you can minimize labor laws litigation between you and employees. That is one part. Now, when you place a purchase order with the other party, it is also a contract. You have to enter into a written document. This written purchase order, it documents a number of goods along with its price, delivery date, timelines, terms of payment, and other details. So this becomes legally enforceable. So you have to very meticulously incorporate all the specifics in your contract, even in a purchase order, which is again a contract. Now, one aspect is very important in every contract. Whenever we are entering into a contract, either between us and our employees, or between us and our buyers, or between us and any other third party with whom we are going to enter into business with, then there has to be arbitration clause. What is arbitration clause and what is the purpose of arbitration? The basic purpose of arbitration is to minimize litigation and quick disposal of the dispute. This is popularly known as ADR, Amicable Dispute Resolution Mechanism. So here in the contract itself, an arbitration clause is to be incorporated. There is Arbitration and Conciliation Act 1996, which has been amended from time to time up to 2019. Is there any disturbance? Or I am audible still? I'm
It's
audible.
going fine, sir. It's
Okay,
going very
okay.
fine.
So the arbitration clause, what is arbitration? Whenever there is civil dispute or industrial dispute arising from what? Again, arising from contract, whatever we have agreed to between us and the party with whom we have made a contract. Terms and conditions have been stipulated in the contract. Whenever there is any contravention of any of the terms and conditions of the contract, then arbitration comes into play. So what happens in arbitration? We have to issue a notice to the opposite party under Section 21 of Arbitration and Conciliation Act. In that notice, what we are required to do? We have to simply seek consent from him. My dear friend, this is the contract between you and us. Such and such dispute has arisen between us, which is relatable to the terms of the contract between us. And I propose to appoint so and so person as sole arbitrator. Please give your consent. Normally and usually he will not give his consent to the person whom you are nominating, because presumably the arbitrator you are proposing is your own man. So he will not give consent. So either he will send you the reply in refusal, or he will not at all reply. So what will you do next? After your notice is delivered to him, you have to be having the proof of delivery. If you have sent by speed post, you have to have the tracking report from the postal website. Yes, it has been delivered. From the date of that delivery and after expiry of 30 days from the date of that delivery of notice, on 31st day, right accrues in your favor to move to a court of law clause will clarify. Either you nominate your arbitrator and other parties also given a right to nominate his arbitrator, and then both the arbitrators have to agree to the payment appointment of third person as principal arbitrator. That mode of appointment of arbitrators should not be resorted to in your contract. Why? Because that is very lengthy and time consuming. All the three arbitrators hardly sit together. One absents, the date goes, time goes, your money goes. So that is a lengthy procedure. You should always incorporate arbitration clause, making provision for appointment of sole arbitrator. Because here you can always appoint your own arbitrator or nominate your own arbitrator. If the consent is not there from the other side, you can immediately move to court, and within 2 dates of hearing, the court will appoint some arbitrator, sole arbitrator of its choice. neither yours nor other parties. Usually a retired judge is appointed. So that arbitration clause in the agreement is always independent of that contract, meaning thereby arbitration clause is itself a contract in the contract. If arbitration clause is there, what is the other benefit to minimize litigation? The other party cannot move to civil court for recovery of any dues or for any other relief. The jurisdiction of civil court is barred under Section 8 of Arbitration and Conciliation Act. So your dispute resolution becomes quick and speedy. Less time is wasted, less money is wasted, and you need not to go to court except for limited purpose for seeking appointment of a sole arbitrator by way of order from the court, because the other party is not agreeing to the person nominated by you as sole arbitrator. So this is arbitration clause and the importance of arbitration clause in commercial contracts. Now the legal issues that are faced by startups, issues with licensing and permits that I have already touched upon. Now it comes marketing and advertisement. We all know very well that this is an era of e-commerce. Just Mr. Ashwini Sharma has raised a question. I am given to understand from my court staff. Mr. Ashwini Sharma says, question is 138 of NI Act and its implication, how one should deal with it. Okay. Number one, 138 of NI Act is in respect of dishonor of check. Here the offense is never the dishonor of check. What is the offense given in this act? You have issued a check to someone in payment of legally enforceable liability. Again, I emphasize on the words legally enforceable liability. If the liability is itself illegal, I have gambled with you, I have issued a check. The transaction is illegal. 138 is not maintainable. No court will take cognizance of such an offense under Section 138. So liability has to be legal and legally enforceable. Now, you have issued a check to someone in payment of some legal liability or part of a legal liability, part payment. Check bounces for any reason whatsoever. Not only insufficient funds, not only your signature differs. Now, Delhi High Court has come down for any reason whatsoever. If it is not credited to your account, it is bounced for the purpose of and covered by the provisions of Negotiable Instrument Act 1881 as amended up to date. Check has bounced. Now, check will come to you with bank memo slip. As soon as you receive the bank memo slip, you are enjoined with the duty that you have to get a legal notice of demand issued through an advocate within 30 days of date of receipt of such legal memo from your bank. If you are late even by a day, you are gone. 138 is not available to you. So strictly within 30 days, and the time is not condonable by any court of law. Remember, here in issuance of legal notice of demand under Section 138 small b of NI Act. So within 30 days, you have to issue notice. Again, the notice has to be shown by you to have been delivered to him by way of postal proof, or now the courts have allowed in Indian Bank Association versus Union of India. Supreme Court has allowed issuance of notice by e-mode also. And more particularly, after this corona pandemic, the communication of notices by email or even WhatsApp, furnishing proof thereof that it has been read by blue lines, showing blue lines, it has been read, you take a screenshot and file with the court. So once it is served upon him, then there is again a grace period of 15 days in this act. After service of this legal notice, he enjoys 15 days to pay you back the amount of dishonored check. If the check was for 5 crores, he will return you, he'll pay you back 5 crores. He has 15 days with him as a grace period. The moment 15 days expire, on the 16th day, you will have a cause of action to knock at the doors of criminal court. Then you can file case, and case will go on, number one. Number two, this 138 NI Act is a criminal remedy which is simultaneously and additionally available to you besides civil recovery suits and civil mechanisms in civil law. It is not that you have filed a case under Section 138 NI Act, then now you are barred from filing a civil suit for that. No. You can file both the cases together at a time. There is no bar. Again, even if there is arbitration going on, then also 138 is simultaneously available. Supreme Court has said it. You can file 138 case. There is no bar, even if arbitration of dispute resolution mechanism or the process is going on, negotiations are going on, let them go. 138 will move at its own place separately.
Sharmaji, can I talk?
Yes.
Can I ask you further?
Yes, sir.
शर्मा जी, इसमें जो हालांकि 138 का जो आपने बताया है,
जी.
मैंने इसलिए पूछा ये क्वेश्चन because most of the people are in the industry already and some people are already running.
Yes.
So they issue checks sometimes.
Right.
Suppose it get bounced, then what are the liabilities? If it is bounced, the other person who has gone to the court and the court is not considering at all, and they issued a warrant. In one case, I know one of my colleagues, he was a director only, simply director. He resigned from that company long back in 2014. Still, he is being harassed by the court. Delhi itself, he is living in Ahmedabad, and recently he has been issued non-bailable warrants.
Yes.
So, Supreme Court and the High Court has already given permission that it is not, because once the man who has already gone, he has not signed those checks. The important thing is that the signatories are more important here. Those who have signed,
sir,
it is bound.
Sir, here the law is slightly different.
What are the implications? How to come out from that? Can you just help me? Because
excuse me. Excuse me. Vijay.
Yes.
I think you answered this particular question, and after that, I'll request all of you to put your questions or reserve them for the question hour session, because he still has to conclude, and Dr. Antal also has to add something.
But Mr.
Thank you so much.
Mr. Ji, I would like to request, since the question has already come.
Yeah, correct. So you answered this question.
I answered this question. Thereafter, all the questions should come in chat box.
Right.
But immediately, I am going to answer this question.
They can be asked one-to-one after your session is complete.
Correct. So I am answering this question
because
it has been asked.
Please.
Here, sir, here the law is slightly different. When the offense under Section 138 is by a company registered under Section 3 of Indian Companies Act 1956, which has now been repealed. Now it is Indian Companies Act 2013. So when an offense under Section 138 of NI Act has been committed either by a public limited company or a private limited company, where the directors are there, board of directors is there, or by a partnership firm. Remember, for the cases under Section 138 NI Act, even a partnership firm is considered as a company in this particular act. So all the rules that apply to directors of a company will equally apply to the partner of a partnership firm. One aspect is this. Number two, what is the law here? The offense has been committed by the company, because the check has been issued by any director or authorized signatory putting the seal of the company of the check. Checkbook was issued in the name of company. Current account is in the name of company in the bank. So company is the primary offender. Therefore, first of all, it is mandatory to make company as the accused number one in your criminal complaint case. Number two, as the dear sir informed me, the director was in Ahmedabad and all that. Complainant is required to simply write, yes, so and so person. When the check was issued to me, in the transactions which I was making with this company, so and so person was responsible for the day-to-day affairs of the company. Either he has signed the check or not is the material. Number one. Number two, here in 138 NI Act cases, unlike other criminal cases, the burden is squarely on the accused to prove his innocence. Here the complainant is required only to prove three things. Yes, check was issued in legally enforceable liability, or either wholly or in part thereof. Number two, it has bounced in the bank, in the account maintained by me in this bank. And number three, I have issued notice within 15 days of the receipt of information from bank that the check has been dishonored. Within 30 days, I have issued notice and notice has been served upon him. I have to simply prove three things. Now, all the presumptions, and either it is under section 139 or under section 118 of NI Act, it is raised against or in disfavor of accused. So it is 138 cases are the cases of reverse burden. The burden immediately shifts on the accused to prove that the check either was not issued towards any enforceable liability, wholly or in part, or it was not signed by him, or he has no liability. He has to prove through evidence, but he will have to undergo the rigor of trial throughout. As the respected sir said, the director was in Ahmedabad, he didn't sign the check. So what? He has to come, he has to face the trial, he has to file Form 32 on the date when the check was issued. I was not the director because Form 32 is there. I had resigned. So he has to furnish legal document from the Ministry of Corporate Affairs office, where the registration of these companies take place. So he has to apply for the certified copy of Form 32 from there and that office, and then he has to file it in his defense in the court. But he has to undergo trial. So this is the answer of this question. Okay, sir. Should I come back to where I was regarding textiles?
Yes, please continue.
Okay, sir. So I have already told ESI Act and EPF Act, which is applicable to any establishment which employs 20 or more persons. 12% has to be the contribution payable by the employer. Something has happened. So I was on advertisement and marketing. And the last thing that I said was that now it is an era of e-commerce. So advertisement and marketing are very important for any startup or any other form of business. But advertising false claims, obscene, scandalous, or seditious advertisement may give rise to severe criminal penalties. and it may blow away the goodwill and reputation of a firm for the startup. Such mistakes may be like stepping over a small growing seedling. For example, I am producing some milk product or milk, say, and I advertise against the interest of a mother who is shown breastfeeding his child. That is not permissible in law. So I have to take care of it while advertising. Now, in advertising by email, what can be done is just a moment. Yes, in advertising and marketing, in the era of e-commerce, we can use social media, Instagram, YouTube, Facebook, WhatsApp. We can have holdings. We can also go for TV advertisements. We can also go for FM radio advertisements. Or as usual, we can go for physical marketing, as we had been doing earlier. We can get our app developed. We can get our website prepared. So in the e-commerce era, these are again additional modes with the help of which we can advertise our products in a better way and quickly without spending much as we were spending earlier in physical modes. Now, there is one very important question for the industries, and that is tortuous liability. What is the tortuous liability? What is our understanding with the word? The term signifies compensations for civil wrong. This is tortuous liability. So in order to escape this burden, the wiser entrepreneur must go for group insurance of employees. He can escape personal burden, group insurance of employees. And he should, this is my opinion, employ a CA and an advocate, keep him on his panel, either as retainer or as employee or whatsoever suits to him. This will heavily reduce litigation costs because they will draft contracts in such a way, incorporating all the terms and conditions, which I say will be protective layers for the entrepreneur, and the litigation therefore can be minimized. So it is wiser to go for keeping, in my view, 3 persons, one advocate and one CA, only 2 persons. CA is always required for taxation purposes. You have to file returns. You have to file all the returns under section 14 itself. You have to file the returns of your company with the registrar of companies office. Here under section 14, you have to regularly file every year the copies of minutes of meeting even. And in company, as we all know, there has to be a seal with embossing. So that seal has to be put and one of the directors has to certify, and the returns have to be filed with regard to minutes of meeting as well. So there you need a CA certainly, because the owner or the director cannot do it himself every time. He'll be busy in developing his business and growing it further. So one CA and one advocate should be retained. And group insurance of policies is a better device to escape tortious liability in many cases. Now, the last thing that comes is IPR, intellectual property rights. Because nowadays, the courts are over flooded with the infringement suits for IP rights. What can be done? There is Trademark Act, there is Patent Act, there is Copyright Act. So again, you would like to have your own trademark of your company. It is a separate procedure. You will have to apply before the competent authority for registration of trademark. Here you have to be very careful. You have to apply for a proposed trademark and you have to pre-check it that trademark that you are applying for is not confusingly similar to the trademarks of other companies who are already there in the similar trade. Otherwise, they will take you to the courts of law. And even registration of such trademark will not be permissible from the department itself, government department. They also check it, but you have to yourself pre-check it. Then you have to apply for domain name. Then you may have to seek patents, your company's name's patent. Amitabh Bachchan has ABBCL. Now it is his company is patented. No other person can use this name, similar name or this name or confusingly similar name. So in IPR plays very important role in minimizing litigations if you are vigilant beforehand. So here also the advocate retained by you would be of great service to you. You will be able to escape all the rigors of Copyright Act and infringement of intellectual property rights. So he will be there to take care. This is all about for a startup. And from my side, I say, next time I'll come with a more complicated subject, insolvency and bankruptcy code that has been put in place in the year 2016. And now there is a flood of court cases before Supreme Court with regard to insolvency and bankruptcy code. Number two, one very important aspect about industries is there. The industry goes sick. Then what are the remedies for rehabilitation of a sick industry? Number one, and what are the laws where we can escape liabilities because it is a sick industry? So next time I'll touch both these important laws. And if there is any question, please put it in chat box. With this, I sum up. Thank you very much for hearing me so patiently. Thank you. Working days.
Yeah.
There has been a question from dear Kamal Mishra. He asked, is it 30 working days or 30 calendar days? Dear friend, 30 working days. Sunday भी उसमें आ जाएगा. अगर बीच में है, Sunday बीच में आ रहा है, तो वो count हो जाएगा. अच्छा, कैलेंडर डेट कहेंगे उसे. संडे भी काउंट हो जाएगा, छुट्टी भी काउंट हो जाएगी. अगर स्टार्टिंग डे वर्किंग है और लास्ट 30th डे वो भी वर्किंग है, तो बीच में सब काउंट हो जाएगा. 30 दिन माने 30 दिन स्ट्रिक्टली.
You told 15 days. I think, is it 30 days or 50 days?
No, sir. 30 days for, you are sending the legal notice.
Okay.
From the date of receipt of check return memo from the bank, that notice has to be sent within 30 days. 15 days period is grace period for the accused. He has to make payment within 15 days after receiving your notice. That is a grace period for him. On 16th day, you have the cause to come to the court.
There is a similar related question by Mr. Professor Damija.
जी
that the bank, when the check is bounced, the bank deducts some amount.
हाँ
In chat box, it is already there. Dhamija ji, I think you can repeat.
when the check is bounced,
Bank deducts the amount. In fact, he is I think, inquiring about justification of that deduction.
number one, the notice has to be issued with regard to the amount of dishonored check alone. You cannot include interest in that. The check amount 4 lakhs plus 18% interest from this period to this period. No, 138, please don't include interest. Yes, if you are going for to file civil recovery suit before a civil court, there you are entitled to interest and
No,
plead
sir,
for
this
interest.
is
Not in 138 cases.
Sir, this is not regarding the interest. This is the fine the bank people, they are actually putting on both the parties.
Fine. Bank parties.
Yeah.
They bank charges, they deduct the bank charges.
Just
and the
just
check
a
is-
second. Just a second. Let me understand. Of course, the amount depends on the check amount. What to do in that case? Can the notice be issued?
If I understand correctly, Professor Dhamija,
Yes,
what
sir.
you're trying to say is that if there's, in the case of a check bouncing, if there's a
Yes.
deduction of a certain amount from your account, from the payer's account, and the payee's account, both. So
Both.
where does the liability actually where does the liability actually stay? Is it the liability stands with the payee or with the payer?
That actually, suppose I am depositing the check to the bank of say any amount,
Yeah.
and it bounces because of say signature is not matching or insufficient balance,
Yeah.
and check bounces, and that check is actually given to the person who is depositing in his account. So the amount of about say 300 rupees is deducted from the payee's account as well as from the person who has actually issued the check.
Right.
In that event,
Both.
sir, I am unmuted. Yes. In that event, sir, you have 15 days grace period after receiving the notice. Better you pay the dishonored check amount within 50 days to the complainant. Your liability is over. But 300 rupees have been, if illegally deducted by the bank, you can sue bank separately.
No, sir, that actually is the rule of the bank these days.
Can we recover this amount from the other party?
Yes. That is what I want to know. Can it be recovered from the person who has actually issued the check?
Yes,
And
that can be done.
Now we can add, apart from the interest, you can add this amount also.
But in the proceeding under section 130 simultaneously, you cannot claim recovery of that amount from the complainant to whom you issued the check. You have to file a separate proceeding under civil law.
Okay. Okay, Dhamija, I think it is now clear. Another question I think raised by it's related to tortious liability. Tortious, in fact, the law, to little more. When there is you have already given some insight about it, but Mishra ji wants a little more. Kindly explain when it arises and how do.
I think the majority of the people may not have understood the real detail of tortious liability. So if you could elaborate on that, please.
Yeah, please. You already discussed this, but kindly repeat.
Yeah, in case
more.
in case the majority of the audience is already understood.
No, I think it's important.
Then,
It is important.
yeah.
It is important. Another important is the registration of the startups.
Right.
We can have little idea on that also.
Mishra ji, you have raised a question regarding tort.
Yeah.
Tort is basically, the foundation of tortious liability is negligence in accident on the part of employer. Suppose आपकी मशीन चल रही है, मशीन का एक पेज खुल गया, कुछ गिर गया और उसका हाथ कट गया है, जख्मी हो गया वर्कमैन का, तो tortious liability तो negligence के बेस पे है, वो तो आपको देना पड़ेगा. You cannot escape that. Suppose आपने फायर एक्सटिंग्विशर सबस्टैंडर्ड लगाई और उस नेग्लिजेंस की वजह से कोई दुर्घटना हुई, क्योंकि टॉर्चुअस लाइबिलिटी ये अंग्रेजों के जमाने में एक पहला केस हुआ था, रेनाल्ड वर्सेस फ्लेचर. वहां से ये स्ट्रिक्ट लाइबिलिटी डेवलप हुई थी कि व्हाट इज द स्ट्रिक्ट लाइबिलिटी. रेनाल्ड वर्सेस फ्लेचर वो आज तक लागू है, तो वो स्ट्रिक्ट लाइबिलिटी से तो नहीं बच सकते. इसके बाद तो बहुत जजमेंट्स आई हैं, पर वो रेनाल्ड वर्सेस फ्लेचर को ही फॉलो किया जाता है. तो नेग्लिजेंस अगर है एम्प्लॉयर की, यू विल हैव टू पे.
बेसिकली
उसके लिए
बेसिकली हमारा यही हम सबके दिमाग में ये डालना चाहते थे कि tortious liability is related only to negligence in the work area.
Yeah, negligence is the foundation.
Yes.
And here the rule of res ipsa loquitur has also been made applicable by Supreme Court from 2014 by a 3 judges bench, because earlier in medical negligence cases, for example, and that case is also relatable to medical negligence case, what was happening? मेरी बाईपास सर्जरी हुई हॉस्पिटल में, अब मुझे केस डालना, मेरी गलत कर दी उसने, डॉक्टर ने, मुझे नुकसान हो गया या मैं मर गया या नहीं मरा तो मेरी इनकैपेसिटेटेड हो गया, जो भी मुझे हुआ, अब मैं केस डालूंगा कंज्यूमर के रूप में, कंज्यूमर कोर्ट में, डॉक्टर और हॉस्पिटल के अगेंस्ट. तो पहले जिम्मेदारी, जिसे बर्डन ऑफ प्रूफ कहते हैं लॉ में, वो थी पेशेंट की कि आप प्रूव करो कि डॉक्टर वाज नेग्लिजेंट. 2014 में 3 जजेस बेंच ने इस लॉ को पलट दिया. उन्होंने कहा नो, डॉक्टर विल हैव टू प्रूव दैट ही वाज नॉट नेग्लिजेंट. दिस इज कॉल्ड रूल ऑफ रेस इप्सा लोक्टर दैट हैज बीन मेड एप्लीकेबल.
सर पूछना था
प्लीज नवीन जी.
सर, मान लिया एज एन एम्प्लॉयर मेरा एम्प्लॉई है, वो कोई बिजली का काम कर रहा है, मैंने उसको हेलमेट भी दिया है और ग्लव्स भी दिए और सेफ्टी शूज भी दिए प्रॉपर क्वालिटी के, लेकिन वो साइट पे उसने वो नहीं पहने हुए और कोई एक्सीडेंट हो गया, तो टॉर्चस लाइबिलिटी, एक तो आपने बता ही दिया कि भाई इंश्योरेंस लो, वो तो हो गया, एक पॉइंट हो गया सर, उसका रेमेडी आपने बता दिया, लेकिन उसके बावजूद मतलब मैंने सब चीजें प्रोवाइड तो कर दी, लेकिन उसने यूज नहीं की और एक्सीडेंट हो गया, तो मेरे ऊपर लाइबिलिटी क्या मतलब वो रहेगा ऐसा?
आपकी नेग्लिजेंस यहाँ आ गई सीधी सीधी. उसने हेलमेट नहीं पहना, उसने नेग्लिजेंस दिखाई, आपने उसे साइट पे एंट्री क्यों दी? हियर यू आर नेग्लिजेंट. आपका सुपरवाइजर भी होगा वहां, 25 लेबर काम कर रही है तो एक सुपरवाइजर भी 100% होगा. उसने क्यों नहीं उसे रोक दिया काम से अगर उसने हेलमेट नहीं पहना?
नहीं, अगर सर मान लिया वो एक आदमी को मैंने
तो आप
कोई
विकेरियस
चीज
लायबिलिटी
रिपेयर
में आ
करने
गए.
के लिए नोएडा भेजा, गुड़गांव में मेरा ऑफिस है, वो रिपेयर करने के लिए नोएडा भेजा और उसने साइट पे जाके, वो अकेला ही आदमी है, सेफ्टी तो भी लाइबिलिटी कंपनी की ही रहेगी?
सर इट इज बेस्ड ऑन नो फॉल्ट थ्योरी. एम्प्लॉयर की लायबिलिटी बिल्कुल रहेगी, नंबर 1. नंबर 2, दिस इज माय पर्सनल एक्सपीरियंस इन कोर्ट्स ऑफ लॉ about these cases, because I have dealt with some 3-4 cases कोर्ट हमेशा वर्कमैन के ही फेवर में रहती है। जजमेंट सुप्रीम कोर्ट की आती हैं वर्कमैन के फेवर में ही आती हैं। वो नो फॉल्ट थ्योरी चले जाते हैं, नेग्लिजेंस किसी न किसी तरह एम्प्लॉयर की मानते ही हैं। ग्रुप इंश्योरेंस कराओ ना, मिनिमाइज इट।
Thank you. I think, Samay, I think it's 1 o'clock now, and you have almost covered every.
Yeah, I mean, if you would like to add something, please.
In fact, I just wanted to, not adding anything. Everything is being covered. Only thing, one aspect I wanted to, the highlights from the Mr. Vijay Samajit, that what about the registration of, because the startup needs to, where they should go for registration, which mode of registration of their startup is easy, whether they should go for Society Act or whether they should go
No. I'll answer.
Company Act also.
I'll answer this question until sir. Yes, I got your point. I got your question thoroughly well. If there are 3 modes, one, proprietary firm, which we popularly call proprietorship firm. In fact, in law, there is no word proprietorship. It is proprietary firm. There is no requirement of any registration, except your other registrations, this taxation registrations and all that. But there is no requirement of any registration. Now, you are a partnership firm. It is required to be registered before registrar of firms. I tell you one thing more. The partnership is governed by the rules and regulations and clauses of Indian Partnership Act 1932. Here in this act, there is section 69. Suppose your partner has siphoned off money. You want to sue him unless your partnership firm is registered. And unless, not only registered, your name as a partner appears in the register of partners in that office of registrar of firms, you cannot sue, you are barred. So as far as partnership firm is concerned, it is required to be registered before registrar of firms. Now, private limited company or any company, they are required to be registered before registrar of companies under Ministry of Corporation Affairs, as Nehru Place office is there, under section 3 of Companies Act. This is the only requirement of registration initially.
What about the firm which is non-profit making organization in the Companies Act?
Companies Act covers only this private limited companies, or there is one more form, LLP, limited liability company. Here the benefit is if there is any liability of the company afterwards, then the personal assets of the directors would not be adjusted against that debt or liability. He'll escape it.
Okay, thank you, sir. I think we had a very wonderful and...
I have one question until, sir. I have one small question, please. Sharma, just let me know in case of proprietary firm, for the startup, I'm asking in the interest of startup people, what is the advantage of getting it registered under Udhog Aadhaar or SMSME? Is there advantage or any disadvantage attached to it? Udyog Aadhaar. Udyog Aadhaar and SMSME.
MSME. Sir, Udyam bol jo Udyam.
I'll come back with the answer next time because I am not aware of. Please put it in chat box. With due diligence, I'll find the answer properly and I'll come back next time. But one thing I forgot to mention, all the companies, either they are firms or companies, they have to seek compulsorily their PAN card also in their name, in the name of company or firm. That I forgot to mention. So now, अभी इनके क्वेश्चन से मुझे याद आ गया, वो भी कराना पड़ेगा. आधार वो बनवाना पड़ेगा पैन कार्ड कंपनी के नाम पे.
Yes, sir. It is only possible when you register it somewhere. Even some company universities are registered by the act of legislation, corporations, and then you can various mode of shop and establishment act is also there. If you want to set up your own tiny kind of a.
I'm in my office and my colleague is here, Mr. Nadine. If you allow, he want to answer that question of Udyam and all that.
Yes.
On my behalf, he'll answer. Because we want answers. We don't want Vijay Sharma or person.
Yes, sir.
I'm giving to him.
Mr. Yes, it will be nice. Welcome, Nadeem, sir.
So, sorry to all of you, मेरी English is not a good. तो मैं अगर हिंदी और आम लैंग्वेज में बताऊं तो थोड़ा मेरे लिए कन्वीनियंट रहेगा. I will try.
बहुत सही रहेगा.
नदीम जी एकदम आप बिल्कुल राष्ट्रीय भाषा में बोलिए, कोई दिक्कत नहीं.
थैंक यू सर. उद्यम और जो एसएमई है, इसमें बिजनेस पर्पज के लिए दो फायदे हैं सब्सिडी के. एसएमई में अगर रजिस्टर हम कराते हैं तो कोलेट्रल रखने की रिक्वायरमेंट नहीं है बैंकिंग के लिए, क्योंकि ज्यादातर जब हम बिजनेस लोन वगैरह लेते हैं तो कोलेट्रल पर्पज के लिए हमें कोई प्रॉपर्टी या तो मॉर्गेज रखनी होती है या गारंटर देना होता है. तो एसएमई में जो एसएमई प्रोसीजर है बैंकिंग के जो चल रहे हैं, उनमें कोलेट्रल रिक्वायर्ड नहीं है. पहली चीज ये है. दूसरा, विदाउट गारंटी ये पेमेंट जो लोन की है वो मिलती है. उद्यम में और इन दोनों में सब्सिडी भी है जो गवर्नमेंट की तरफ से जो स्टार्टअप कर रहे हैं उन लोगों को आई थिंक 20 to 25% ऑफ इंटरेस्ट में भी सब्सिडी मिलती है.
नदीम जी, इसमें आपका जो है, आपने एसएमई बोला, एसएमई और एसएमएसई
एक ही दोनों
कंसीडर कर रहे हैं ना? राइट
जी, दोनों एक ही.
And that's why I put in this question, because it's very relevant to the freshers, the new startup people, to look at the financing part also.
विकास, एक चीज और ऐड करना चाह रहा था मैं.
हाँ जी.
नदीम साहब ने बताया ही है, बट जो बिगेस्ट एडवांटेज है ना एमएसएमई रजिस्ट्रेशन का, that is कि any corporate cannot hold your payment beyond 45 days.
Absolutely.
Yeah.
Absolutely.
Payment terms maximum permitted by the government is 45 days. And उसको इवन अपनी बैलेंस शीट में ये डिक्लेयर भी करना पड़ता है कि कोई भी एमएसएमई वेंडर की पेमेंट 45 दिन से ज्यादा पुराना इनवॉइस मेरे यहाँ पे पेंडिंग नहीं है, जो कि कोई पंगा लेता नहीं. तो एमएसएमई रजिस्ट्रेशन से जो सबसे सिग्निफिकेंट एडवांटेज है वो है आपकी पेमेंट थोड़ी सिक्योर हो जाती है. ये मुझे नहीं पता कि अगर एमएसएमई स्मॉल या रिटेल में कुछ बेच रहा है तो भी सिक्योर होती है कि नहीं, बट कॉर्पोरेट के साथ हो जाती है, दैट आई एम श्योर.
सिक्योर है सर. नॉट ओनली द कॉर्पोरेट, ये एसएमई लोन के लिए जितने भी स्टार्टअप वाले या शुरुआती लोग हैं उन सबके बेनिफिट के लिए ही ये किया गया है. प्लस 138 एनआई एक्ट के जो केसेस हैं उनमें भी अमेंडमेंट करके 143A एक सेक्शन ऐड किया गया. उसमें भी यही है कि अगर हम कंप्लेनेंट हैं, हमारा पैसा फंसा हुआ है और उसने हमें चेक दिया हुआ है और चेक बाउंस हो जाता है, तो जब उस पर चार्ज फ्रेम होंगे, जब उस पर नोटिस फ्रेम किया जाएगा, तो वहां पर कंप्लेनेंट के पास में एक राइट आ जाता है कि वो 143 की एक एप्लीकेशन लगाए कोर्ट में, तो चेक अमाउंट का 20% 90 डेज के अंदर रिलीज करा देगी, कोर्ट ऑर्डर करती है. ये इंटरिम रिलीफ है कि जो कंप्लेनेंट है उसको, मान लीजिए 1 करोड़ रुपए का चेक है, 1 करोड़ रुपए का चेक है और एक मुकदमा कोर्ट में लड़ेंगे तो कम से कम 2 साल चले जाते हैं. अब 1 करोड़ का अमाउंट बिजनेसमैन के लिए, अपने बिजनेस को फैलाने के लिए बहुत बड़ा अमाउंट है. अब चूंकि टोटल अमाउंट एक साथ दिया नहीं जा रहा है या दिया नहीं जा सकता है एट दिस स्टेज, तो गवर्नमेंट ने 143A ऐड किया और इंटरिम मेजर के रूप में 20% इसमें इनिशियली देने के लिए ऑर्डर किया कि अगर कोर्ट को लगता है कि इनिशियल अमाउंट 20% तक हो सकता है तो वो 20% तक के ऑर्डर कर सकता है, जिससे 1 करोड़ की लायबिलिटी मान लीजिए एक्यूज पे है तो कम से कम 20 लाख रुपए कंप्लेनेंट को दिलवाएं, जिससे वो अपना बिजनेस आगे प्रोग्रेस कर सके इनिशियल शुरुआती अमाउंट.
नदीम जी, थैंक यू। चाहे कोई भी बिजनेस हो, छोटा हो या बड़ा हो, पेमेंट्स हमेशा बैटल ग्राउंड रहते हैं, और उसमें जो एसएमएस जो हैं उनके लिए बड़ा क्रूशल हो जाता है, स्टार्टअप्स के लिए बहुत क्रूशल हो जाता है, क्योंकि उनके सर्वाइवल का मुद्दा आ जाता है यहाँ पर।
एग्जैक्टली सर।
थैंक यू सो मच। थैंक यू
सर। थैंक यू ऑल ऑफ यू। मैं विजय सर 1 मिनट के लिए आप लोगों से।
Thank you very much for giving me an part of this important one. Number 2, program is matter of
विजय जी, एक रिक्वेस्ट आपसे है कि नेक्स्ट जब भी आप करेंगे, प्लीज, अंतर जी से भी बात हुई थी, प्रॉब्ली द टू ऑफ यू कैन कोऑर्डिनेट। अगर आप इसको पावर पॉइंट प्रेजेंटेशन के बेसिस पे आप ले ले, तो सबके लिए स्क्रीन सेव करके जो पॉइंट अभी नोट्स किसी ने बनाए होंगे, किसी ने नहीं बनाए होंगे,
ठीक है।
तो लेकिन इंटरेस्ट हर एक का बनेगा। अगर आपकी स्लाइड्स होंगी तो वो स्लाइड सेव कर देंगे और उसमें क्वेश्चन उनके ज़्यादा इजीली आ जाएंगे, और शायद आपके लिए भी थोड़ा सा इजी होगा उस फ्लो को मेंटेन करने के लिए। अंकल जी, वुड यू लाइक टू ऐड समथिंग प्लीज? अंकल जी, आप म्यूट पे हैं।
Okay. So it's a very encouraging and learning session today. We had, I think it has met the participant expectations. I would also like to thank from my side and on behalf of the organizer, the audience, particularly without their support and cooperation and without their presence, it would have not been possible to organize such seminars. Management committee, particularly the Sir, National President Vikas, the President of the Delhi chapter, DK Singh, Somaji from National Office, Ashwini Sharma ji, KK Sharma ji, they took pain to present today to encourage the particular speaker so that we can organize much more further programs. Kamal Mishra ji, Yogesh ji, and I think Ritesh, they have worked a lot without their networking, cooperations, and back work for this seminar. This would have not been possible. There are various special guests. Mr. K. Chatterjee is there, and one more person is Damija. I thank them. I also take this opportunity to thank them on behalf of the TAI Delhi unit also. And with these words, I'll request Mr. Vikas Chatterjee, who is the president of the TAI Delhi, to say a few words and the closing ceremony. Thank you, everyone.
I'll intervene for a moment. I have observed that quite a few ladies have joined. I'm very thankful to them. I'm very thankful to them for having taken this initiative, for having come forward. But please, let me also admit that I'm slightly disappointed because we have not received even a single question from their side. Please be more interactive. We would like to learn from your questions, and we would like the others to get educated by your doubts. Thank you so much. Thank you. Vikas, please.
Vikas, you unmute कीजिए.
Vikas, you have to unmute.
I joined a bit late. I'm sorry for that. But when I joined, it was really very information was going on. Thank you very much, Sharma ji and until sir, you have taken a lot of point, very important point for the startups people. And this MSME and the Udyam, these also need to be more focused for the new upcoming these people, the entrepreneur, because this is going to give them a lot of help to build up their business. One, Naveen ji also mentioned with the payment security of 45 days, bank subsidies for the interest rate, and the without collateral bank loans is also a good advantage to join this kind of government schemes, MSME or Udyam. I thank you very much, all the participants and all the team of TAI Delhi. And this will be uploaded very soon on our YouTube channel also. So we can circulate it to the other friends in known circle who are the new venture into this business, or the new startups are there. So they can also get some information in this. Thank you, everyone.
Sorry, just one last word. If any of the participants have any questions, the ones who have been here, and once this gets circulated in a much wider audience on the YouTube and on other media, if people have any questions on these aspects, I would request them to send them to Dr. Antal, and they'll be answered through TAI in collaboration with Mr. Vijay Sharma. Thank you very much. Thank you.
Thank you everyone.
वो तो ड्राई ये हाँ हीट वाले उनका वाला जल गया। अच्छा, बाकी का भी खराब है। ये तो यही पड़ा है जो हमने काटा था। अच्छा, ठीक है, सुन लीजिए। ठीक है, वो मशीन जो है।
रितेश जी आप क्लोज कर।
Okay, thank you everyone.
Guys.